Hello, I'm Joseph Neuberger, and welcome to Neuberger Rose Online. I'm joined today by my partners David Rose and Stacey Nichols, and we're here to discuss drinking and driving and other impaired-related cases. David, is it true there's zero tolerance on drinking and driving cases now?
Well, we have to be very clear about what zero tolerance means. There's zero tolerance for impaired driving, as it's known in the criminal code. There's also zero tolerance for driving with over 80 milligrams % of alcohol in your blood. Zero tolerance means those two things. However, it's possible to have one or two drinks, and as long as you're driving with less than 80 milligrams % and you're not impaired, then that's not a criminal offense. It's a little different when it comes to provincial legislation and license suspension and the license implications of drinking and driving, because if you're driving with over 50 milligrams %, while it's not a criminal offense, that could result in your license being suspended by 7 days.
Okay, so there's a distinction between the Provincial Highway Traffic Act legislation and the criminal code.
Absolutely, and they capture different types of remedies.
Okay. Stacey, is it true that if somebody is found guilty of a drinking and driving related offense, they can still drive?
In certain circumstances, they can. On an early guilty plea, and after having installed the ignition interlock in your car, as well as going through several other steps outlined by the ministry, you can potentially receive your license back.
So an individual would have to apply to the ministry to be eligible for the program, and it comes up front with a minimum of a 3-month period of suspension. Is that right?
That's true. The ministry has complete discretion when it comes to the ignition interlock program, and it's not necessarily everyone convicted or everyone who pleads guilty early who would be eligible for the program. For example, if you have a prior offense, you're not likely to be eligible for the program, or if you're involved in a more serious drinking and driving offense, which involves an accident or something like that.
But if somebody resolves a case in that manner, they're still guilty of an offense and they still have a criminal record. Is that correct?
Absolutely.
Okay, well, let's talk about something different. Can a person only be charged with being impaired by alcohol, or are there other means in which someone can be charged?
It's always been an offense to drive a motor vehicle while impaired by a drug. It's just been a little bit more difficult for the prosecution to make out that type of case. The last few years, the government's changed the legislation so that now they have what are called drug recognition experts. These are specially trained police officers who administer a battery of tests on a driver to find out whether they are impaired by, for instance, marijuana, cocaine, opiates, or things like that.
Prescription medication, for example.
Even that, too, absolutely. And that's a very technical way of defending a case. We've done many of those cases over the years at Neuberger Rose, and it's important to absolutely know what those tests will prove, but more importantly, what they won't.
Well, Stacey, in an impaired by drug case, do the officers apply a test similar to an impaired case by alcohol, and that there's something you blow in? Or are these a subjective test that the officer conducts himself?
Well, I think they are. I mean, in a regular drinking and driving offense, an officer generally uses very common indicia of impairment that everyone knows about. Slurring of words, bloodshot eyes, not walking in a straight line. Now, some of the tests that they use in the drug impairment cases are similar, but they're more specialized and more refined, and there's actually officers who are very specially trained in order to detect impairment by drug.
So the sense I'm getting is these types of tests the officers are applying are really quite subjective because they're observing behavior and they're making determinations upon what they're seeing. How does that allow a seasoned criminal defense lawyer to attack that type of case?
Well, I think you have to understand these tests as well, if not better than the police officer who's testifying. So you have to understand with these tests, first of all, how they're properly administered, and they have to be very specifically administered under difficult circumstances, and that's a method of attack for a good lawyer. Because these tests are not taken under ideal circumstances at a police station. Quite often it's at a roadside of a busy freeway and with no lighting and so forth. But I think it's also important to know what these tests will not show. So for instance, there's limitations to each test, and these are known in the literature, so they have what are called false positives.
Right.
It's important for the lawyer to understand what limitations are attached to those tests to defend the client properly.
I think it's important then for a defense lawyer to have a good understanding and knowledge of the scientific basis of these tests that the officers are applying in order to attack the case.
Absolutely. These people who have arthritic problems, people who are overweight, those people will have difficulty performing those tests even when they're plain stone cold sober.
Well, thank you. Thank you for joining us at Neuberger Rose Online. If you have any questions regarding this topic or any other criminal law issue, please join us at www.nrlawyers.com. Thank you very much.